Hello my dear friends and welcome to StudyIQ. I am Joy and today in this lecture we will discuss about the 103rd Constitutional Amendment Act. So first let us understand what is this 103rd Constitutional Amendment Act. The 103rd Constitutional Amendment Act provides for 10% reservation of economically weaker sections in public employment, public and private educational institutions. So this is in brief the 103rd Constitutional Amendment Act, and in this lecture we will discuss in detail all the provisions of the 103rd Constitutional Amendment Act. Now if we analyze what is 103rd Constitutional Amendment Act, we will see that 10% of reservation is given to economically weaker sections. Now we will understand what is economically weaker section, what is the definition given by the government later in this lecture, and it is for public employment as well as for public and private educational institutions. Now coming to the need for such a Constitutional Amendment Act. The first reason is the inequalities prevalent in the Indian society. So we know that the inequality gap is very wide in India. This is in case of access to education, access to jobs, etc. So there is inequality based on caste and also socio-economic status. That means those who are rich or economically well off, they have better access to education. And when they have better access to education, they also have better access to jobs because of the exposure they have gained from their education. So it is important for a democratic government to narrow down the inequalities existing in the society. So in order to bring out a solution for this inequalities, 10% of reservation for the economically backward sections would be welcome. Now let us understand who all are eligible for this economically weaker section reservation of 10%. Now here we will see what is the definition given by the government to define the economically weaker sections. So 10% of reservation to economically backward sections in the general category. So those candidates or those people who fall under the general category at present, but they are economically weaker sections. So this is the criteria for determining the reservation. So let us see what is the eligibility criteria. The general category individuals, all members of whose family together earn less than 8 lakh per annum. So the income cap is set at rupees 8 lakh per annum. Or second one is those who have less than 5 acres of agricultural land. So in case of land, it is 5 acres, the maximum cap. Now the third criteria, individuals whose families own or possess a residential building of more than 1000 square feet will not be eligible. Now coming to the communities, it covers Muslim, Sikh, Christian, Buddhist and other minority communities. It also includes Hindu community as well. And this quota will be over and above the existing 50% reservation for the SCs, STs and the OBCs. So at present there is 50% or the 49% reservation for the SC, scheduled caste, scheduled tribe and the other backward class. So this 10% will be over and above. That means this 10% will not be included in the 50%, but this will be 50 plus additional 10. That means the new reservation will not be carved out of the existing reservation. It will not affect the existing reservations. Now briefly looking into the details, eligibility people earning less than 8 lakh annually. This is the income criteria, and according to land criteria, people who own farmland less than 5 acres. Thirdly, people who own a house measuring less than 1000 square feet. So this is the eligibility criteria. And the background, in the famous Indira Sauni judgment, the Supreme Court had set a cap of 50% on the quotas. And also, the Constitution of India does not provide for reservation on the basis of economic criteria. So, because of this, a constitutional amendment bill was required, and that is why it is a Constitutional Amendment Act. Now, let us see what is the parliament procedure. Since it is a constitutional amendment bill, Article 368 would apply. This is constitutional amendment bill. So the bill must be passed in each house by a absolute majority. So what is absolute majority? More than 50% of the total membership and a 2/3 majority of the members present and voting. That means absolute majority, that is more than 50% of the total strength, and also a 2/3 majority present and voting. So this is the criteria required for the passage of the constitutional amendment bill, and this was the procedure by which this bill was passed in the parliament. Now let us understand why a constitutional amendment bill was required. Why it is a constitutional amendment act. So let us see the present status. Article 15, that is prohibition of discrimination, and Article 16, equality of opportunity, needs to be amended. So two articles that are amended are Article 15 and Article 16 of the Constitution, and we will find out that Article 15 and 16 comes under the fundamental rights category. Now looking closely into Article 15 Clause 4 empowers the state to make any provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. So here under Article 15(4) we will see that the criteria is socially and educationally backward classes. So this does not cover economically backward classes. So there is a need to add the provision economically backward classes also, and therefore the government has introduced a new clause, that is clause 6 of Article 15. So under the clause 6 of Article 15, this will allow the government to carve reservation for economically weaker sections of the society. So the term economically weaker will be added. Now coming to Article 16 Clause 4. It provides for reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. So here the important term is adequately represented. So if the government feels that a particular group of people, if they are not adequately represented under the services under state, the government can provide reservations. So here also there is no provision mentioned as economically deprived sections. So Article 16 will also be amended in order to add a new clause, that is clause 6, in order to provide quota for economically deprived sections in the initial appointment in government services. So here initial appointment is important because this category of reservation, that is economically weaker section, will not be considered for the promotions. So it is only for the initial appointment in government services. Now let us look at the initiatives in this area. In this area means in the area of providing reservations. So coming to Article 340 of the Indian Constitution, Article 340 mandated that the government should identify those classes which were socially and educationally backward, and government should implement measures to remove such difficulties to improve their condition. So Article 340 of Indian Constitution is a very important article, and based on this Article 340 of Constitution, there was an appointment made. So a commission was created to investigate the conditions of backward classes in the country, and this commission was chaired by Kaka Sahib Kalelkar. So that is why this committee is called Kaka Sahib Kalelkar Committee popularly, and this committee is the first backward classes commission. So this is very important. This was constituted in the year 1953 under the chairmanship of Kaka Sahib Kalelkar. Now the purpose of this committee was to determine the criteria in order to identify people as socially and educationally backward classes, and also to recommend steps in order to revive their condition. So this is the first committee, and the second committee is called the BP Mandal Committee, which is very popular. You might have heard about this committee in various news or newspapers recently associated with this recent 10% reservation. So coming to the second committee, that is BP Mandal Committee. This was appointed in the year 1978. This was the second backward classes commission and the chairman was B.P. Mandal, and that's why this committee is popularly known as Mandal Committee, and the purpose was to review the state of backward classes in the country. And the committee recommended 27.5% reservations in government jobs for OBCs, that is other backward classes. Now coming to the very famous Indira Sauni case. So in this case, the Supreme Court had given a judgment which said that economic criteria cannot be the sole basis of determining backwardness, and in this judgment, Supreme Court had capped the reservations at 50%. Now coming to the legal hurdles with regard to this 10% reservation. So firstly, this is open to judicial review. That means the judiciary, the Supreme Court can overlook into this issue, and this comes under the judicial review. So based on the constitutionality of this, the Supreme Court can either upheld the constitutionality or can struck down this provision. So this is open to judicial review. And the Constitution does not provide economic reservation. So when this 10% reservation matter comes to the Supreme Court as the guardian of the Constitution and as the guardian of the fundamental rights, it will look into the constitutional validity. It will examine this 10% reservation with the constitutional provisions. So, the Constitution does not first of all provide for any kind of economic reservation. And secondly, in the Indira Sauni judgment, the cap has been limited to 50%. So, this is an earlier Supreme Court judgment. So, that also the Supreme Court can consider. Now, if this 10% reservation for the economically weaker sessions gets implemented, this will increase the cap to 60%. So this is against the previous judgment of the Supreme Court. So this is the second hurdle. And thirdly, the Supreme Court in the previous judgment of Indira Sauni held that economic backwardness cannot be the sole criteria for the reservation. So these three reasons can come up before the Supreme Court while validating the constitutionality of this Amendment Act. And secondly, the government proposes or has passed the bill to bring in a 10% over and above the 49% quota. So what existing is 7% for scheduled caste, 15% for scheduled tribes and 27% for socially and educationally backward classes or the OBCs. So altogether this accounts for 49% and now 10% additional. So this will make up 59% reservations. So only 41% is left out for the other candidates. This can be a violation of the Article 14 of Indian Constitution, and this can also sacrifice the merit. So this questions also will come up before the Supreme Court while it makes the judgment. Now coming to the challenges. The first one is the violation of the equality norm. So if the quotas are increased by the state governments, this can offend the equality norm. In the year 2016, in the Nagaraj judgment, the Supreme Court Constitutional Bench ruled that equality is a part of basic structure of the Constitution. And secondly, this can dilute the original idea of affirmative actions. It means that in the history or traditionally, reservations have been provided to those classes who had to undergo historical injustice and social exclusion. So, original idea of reservation for the scheduled caste and the scheduled tribes was that in order to correct the deprivation that they had to face in the earlier times. So, now this providing 10% of the quota can dilute the original idea of affirmative action of providing reservations. And it also affects every category of individuals, because the general category, if 60% of reservations are provided, the rest 40%, which is the general category, these jobs are open to everyone, including scheduled caste, scheduled tribes and the OBC individuals. So by removing 10% of jobs from the open category, that is at present it is 50%, now reducing it to 40%, this will reduce the opportunities for currently reserved groups as well. Now, third difficulty would be to obtain the caste certificates, because already a large number of scheduled caste, scheduled tribes and OBC households are facing difficulties in getting their caste certificates. So, now when a large section of people would require the caste certificates, it would be difficult. Now let us also understand what are the alternatives available. The first one is to spread the benefits of reservations as widely as possible within the existing framework. And it is also important to ensure that individuals who use their reserved category status, they use it only once in their lifetime. Secondly, the government should focus more on developing the basic skills. So, regardless of the caste, class or religion or the status, the government should invest on developing the basic skills in the citizens. This will provide them better employment opportunities and thereby better living conditions. Now, thirdly, the government should bring in reforms and modifications to the existing reservations itself. You can find the PDF of this lecture on my Facebook page, and for any queries regarding your UPSC preparations, you can get in touch with me on my Facebook page or you can email me at joyce.studiiq@gmail.com. Thank you.